Hello and welcome to today's episode of the Indian Lawyer Legal Tips. I am Yash Hari Dikshit. I am an associate at the firm and we have with us Mrs. Sushila Ram Varma. She is an advocate and chief legal consultant of the firm. Welcome, ma'am.
Thank you, Yash.
Ma'am, today I want your insights on a topic that is another episode in the direction of matrimonial laws that we've been doing. So it's on adoption laws in India. So, ma'am, shall I start?
Absolutely. Please go ahead.
So my first question is very basic. Under Indian law, what does adoption legally mean and how is it different from guardianship, which still some communities rely upon?
So, adoption per se means a complete legal transfer of a child from the biological parents to the adoptive parents. Now, what happens is once the child gets adopted, the child has a new legal identity, gets full inheritance rights and other rights associated with being a biological child of the adoptive parents. And I would say the two key features that define legal adoption in India is that the child now becomes or is now recognized as the natural born child of the adoptive parents, and the parents are hereafter, that is, the adoptive parents are hereafter given the responsibility of controlling the child, looking after his or her welfare, and to always keep in mind that they have to look at the best interest of the child.
So, ma'am, what is the actual difference between adoption and guardianship?
Well, to put it very simply, adoption creates parenthood, whereas guardianship is more like a caretaker. Now, let me explain what I mean by this. Now, guardianship is something that is granted under the Guardians and Wards Act 1890. It is not a full adoption. It just recognizes that A, B, or C is appointed as a guardian of a minor child until the child attains majority. Now, it's a possibility that the minor child may have properties, may have other assets, may have money. So, the guardian is supposed to look at not only the child's welfare and the growth and the education of the child, but if the child has any property, to ensure that the property is also cared for. So guardianship is essentially about the care and control, whereas adoption is always about permanent legal parenthood. So like I said, one is a parent, the other is a caretaker.
Alright, ma'am. Moving from concepts to structure, what are the main legal routes in India for adopting a child?
Under the Indian laws, there are three principal legal routes. First is the Hindu Adoption and Maintenance Act 1956, also known as HAMA. Now, this law is a personal law and it applies only to people who come within the category of Hindus, which is Hindus, Buddhists, Jains, and Sikhs. Apart from that, the other communities are not governed by this particular law. Now, this particular law allows adoption of a child if conditions under sections 7 to 11 are satisfied and fulfilled. Once a valid adoption takes place, the child is treated as the natural child of the adoptive parents and has all the rights, including the inheritance rights to their property. Now, let's come to the next act, that's the Guardians and Wards Act 1890. This act focuses on all Indian citizens, be they Muslims, Christians, Parsis, or Jews, or where there is no personal law that guides them as far as adoption is concerned. Now, this particular law creates guardianship but not full adoption. The child does not automatically become the child of the adoptive parents as a child would be in adoption. Often used when families want to take care and custody of children but can't do it because of their personal laws. And also one more thing, it's an 1890 Act, which means it's very archaic and it definitely needs revamping. I think in order to cover this, the lacunas in this Act and the Hindu Adoption and Maintenance Act, the Parliament thereafter passed a law called the Juvenile Justice, Care and Protection of Children Act 2015. Now, the key feature of this particular law is that it is secular in nature and religion neutral route, and it's applicable to all citizens of India. So it is focused on abandoned, surrendered, and declared legally free for adoption children by the child welfare committees. Now, adoption under the JJ Act gives the child the full status of being a son or a daughter, regardless of religion. So the crucial point is that the Hindu Adoption and Maintenance Act and the Guardians and Wards Act continue to operate, but the Juvenile Justice Act offers a secular, right-based framework for everybody who's an Indian citizen. It also helps in the case of inter-country adoptions and institutionalized children because that is where these issues can be covered. So all adoptions in India have to be covered by an order of a court of law.
And now slowly it's been transformed into the court of district magistrate
Yes,
for speed.
but you need the legal approval
Yes,
from a
ma'am.
court of law.
Ma'am, I'll come to that a little later. One of the cases that always pops up when we talk about adoption is Lakshmi Kant Pandey. What was this case about, and why is it the turning point in the adoption laws?
See, Lakshmi Kant Pandey was an advocate and he took up this public interest litigation in the Supreme Court of India way back in 1984. The public interest litigation looked into the issue of the serious malpractice regarding adoption of children and the fact that very often children who were taken in inter-country adoptions were actually taken for trafficking or even treated as commodities. Now, the Supreme Court, after hearing the public interest litigation, came to some path-breaking decisions. The first is it recognized that abandoned, orphan, and destitute children have a right to a family, linking this to Article 21, that is the right to life and dignity. It also laid down detailed guidelines for inter-country adoption. So only recognized child welfare agencies could process such adoptions when it came to inter-country. Further, it mandated that home studies of foreign parents was a must. There was also scrutiny and supervision by reliable agencies of the government, and regular post-adoption follow-ups have also become the order of the day after this particular judgment. Most importantly, the Supreme Court directed, or rather, the Supreme Court recommended setting up of a central agency which eventually would look into adoption in different aspects. And that is how CARA, that is Central Adoption Resource Authority, came into being. Subsequent orders were passed by different courts, and these orders have made the entire process much smoother. But in short, L.K. Pandey is the first case by which a loosely regulated and often exploitative intercountry adoption space became child centric, regulated, and a tone was set for the adoption jurisprudence.
Okay, ma'am. Another landmark case is Shabnam Hashmi versus Union of India. What was at stake there, and what did Supreme Court finally held?
Well, Shabnam Hashmi was a Muslim activist and who wanted to adopt a girl child. Under Muslim personal law, there was nothing by which she could adopt a child. So she wanted to be treated as the mother, but she was treated as a guardian, not as an adoptive mother in the full legal sense. The child's inheritance and status obviously would have remained uncertain if the child was only a ward. So she approached the Supreme Court of India for clarity and recognition. The Supreme Court made three big moves. The first, it held that the right to adopt is not in itself a fundamental right under Article 21. However, the Parliament is perfectly competent to create an enabling secular adoption code. It recognized that the Juvenile Justice Act provides a religion neutral route to adoption when it is for adoption by religious communities other than Hindus. So Muslims, Christians, Parsis, Jews can all avail of the adoption route through this particular act. The JJ route also does not abolish or override any personal law. It is a secular law, and it is more, it is more to ensure a smooth operation of adoption rather than be overriding or contradicting any previous laws. And it also clearly states that a child adopted under the JJ Act acquires the same status as a biological child, that is a natural child, even if the adoptive parent's religion traditionally does not realize adoption. So, what this particular judgment did was that though Shabnam was a Muslim lady and there was no personal law, they recognized her adoption under the GJ Act. And this, I think, would be something very important. It set a trend for religions other than Hindus.
Okay, ma'am. Now, ma'am, I want to talk about single parents.
Mhm.
There was this case called ABC versus State in City of Delhi. Why is it so important for unwed mothers?
Well, in this particular case, ABC versus State in City of Delhi, a 2015 judgment, the lady in question was an unmarried Christian mother and she wanted to raise a child on her own. So she went to the court seeking to be declared as a sole guardian, but the authorities refused to allow her because they said she was not disclosing the biological father, whom she did not want to meet. So the matter finally went up to the Supreme Court. Now, the Supreme Court held that an unwed mother can also be sole legal guardian of her child. Courts cannot force her to reveal the father's identity, and there must be a reason why she is not disclosing. I mean, it could be her own privacy, her dignity, and autonomy, and also keeping in mind the child's best interest. It also condemned discrimination based on marital status. It said a woman does not lose her capacity to be a good parent just because she is not married. So the judgment effectively strengthens the legal position of single and unwed mothers, not only in guardianship but also for adoption. And it affirms that family is about caregiving and responsibility, not just marital labels, which aligns with Articles 14 and 15 and 21 of the Constitution of India.
Ma'am, you just mentioned about the GJ Act. How does this 2015 law actually structure adoption, and what did the 2021 amendment change?
The 2015 JJ Act puts adoption into a tight statutory framework built on the child welfare and also recognizes due process. Now, the key features of this 2015 Act, insofar as adoption is concerned, is it applies to orphaned, abandoned, and surrendered children who are declared legally free to be taken up for adoption. It recognizes in country adoption as well as inter country adoption and step parent adoption also. It mandates that prospective adoptive parents must be physically, mentally, and financially stable and generally motivated by the child's welfare. Also, it says that once an adoption order is passed, the child is treated as the natural child or the biological child for all purposes, including inheritance rights. Now, after this law was passed in 2021, the Parliament felt that there was a need to make an amendment. So they made an amendment, which is the 2021 amendment, which finally came into force in 2022. Now, what happened was that the Parliament realized that adoptions were taking too long when they were before the court, and as such, the Parliament felt that the order that an adoption was legal, valid, and binding should be shifted from the district court to the district magistrate or the additional district magistrate because it saved a lot of time. Now, these bodies, the DM and ADM, are only quasi judicial, but the idea was to speed up the process. Now, yes, in all child related matters, we know how fast children grow up. Now, if a court process is going to take years at an end, a minor can become a major. Then you don't even need to get permission of the court, right? The major has the right to decide who his parents are. So that was probably one of the reasons. They must have thought it will help to reduce the backlog and things would move faster. Of course, the concern on this amendment is are the DMs and ADMs fully capable of deciding such an important issue, and how do they decide whether the best interest of the child is there. Now, no matter what changes we make, there will always be there will always be comments in favor and also against. So similarly, I think this is also one of those cases But I personally feel that if delay is the key issue, then it's something that's very important.
Definitely, ma'am. When we keep mentioning CARA, what exactly does CARA do, and how have these regulations and technology changed the practical adoption process in India?
Well, CARA stands for Central Adoption Resource Authority, the only and main authority that deals with adoption. It's a statutory central authority for adoption in India that not only recognizes inter-country adoption but also in-country adoption, and this has been formed under the Hague Convention on Inter-Country Adoptions. Now, CARA's main roles, I would say, would include that they would be in a position to regulate, that is, the in-country adoption as well as inter-country adoption. Apart from that, they have specialized agencies which can supervise the process of adoption. Then they also maintain an online portal where people can register. See, in today's day and age, the demand for children is so much that you have more parents than you have children. So the entire process, the waiting is quite long. Sometimes it can take 6 to 8 months or even a year. Also, CARA will get a no objection certificate for inter-country adoptions, which will help the adoptive parents, if they're from a foreign country, to take the child away. Under the latest adoption regulations, CARA has to clear the adoption process within fixed timelines, and most importantly, they have to do a home study. And post adoption, also, there are certain responsibilities, like they have to check whether the adopted child is given the correct amount of attention, and they also have to ensure that through technology there is a very transparent mode. It's a long process, there is a very long waiting line. So I guess sometimes these things are very essential that there should be transparency, because if there is no transparency, there may be people who will jump out of line and get the adoption because they paid some money. So in that sense, I think CARA is essential, important, and regulates the entire system of adoption.
I absolutely agree with you. If there is a child-centric approach, then there should be transparency. So, ma'am, a lot of debate has also focused on the LGBTQ plus rights and the unmarried couples. After the Supreme Court's marriage equality verdict in Supriya Chakravarti versus Union of India, what do you think? What is their position in adoption law right now?
Well, as far as the LGBTQ is concerned, now what the Supreme Court had a very split verdict in the marriage equality case. Okay, now what happens is when you look at LGBTQ or you look at married couples, what the court essentially was looking at is only married couples should be given, should be allowed to adopt a child, or a single parent. They did not want people from in a relationship to adopt a child. That is probably because of the instability. Today you're together, tomorrow you may not. Whereas if you're married, at least it's for keeps. So I think ultimately what the court always has in mind is to see that there is a stable growth for the child, and the child should not be traumatized. Also, it recognized that if you are a single parent, you can get adoption provided you meet the other criteria, that is financial, emotional, physical, you are stable enough to do all that. So the majority, however, felt they agreed that parental ability is not determined by sexual orientation, and therefore, even if you were an LGBTQ and if you were stable enough to adopt a child, it could be allowed. But of course, marriage of LGBTQs in India is not recognized, so they can never become a married couple.
All right, ma'am. Stepping back, what are the biggest structural challenges in India's adoption ecosystem right now?
I would say that India in all personal laws requires to have a uniform code. I mean, you have different laws for marriage for different communities, you have different laws for divorce, you have different laws for adoption. So it gets a little confusing. So right now we have three laws, right? The Hindu Adoption and Maintenance Act, the Guardians and Wards Act, and the Juvenile Justice Act. So I would say multi-regime complexity is something that our country is definitely facing. It also becomes very difficult for people who want to adopt and don't know which way to go. But I guess that's the reason why we lawyers are there to advise them. Then another aspect that I notice very often is the supply-demand match. There are more parents in the market, prospective parents in the market than children. So again, this means long waiting lists. Then there is of course the shift from the district courts to the district magistrate as insofar as order of adoption is concerned. This has again made people wonder that such a sensitive topic, can people like the district magistrate and the ADM take a decision, and would the decision be correct? Would it be considered as good as an order from court? But like I said, Yash, one has to bear in mind that in adoption matters, time is a very essential and crucial factor. Then exclusion of unmarried and queer couples from joint adoption is something that maybe with the passage of time will be considered by the courts, but too early to say. Okay. And post-adoption support and counseling, I think, is something that really should be looked into, because bringing up a child per se is not very easy, and you definitely need counseling and psychological support. And some children have medical issues, so those kind of parents, people who have adopted them, require even more support. So I would say that while the system is morally and constitutionally committed to child welfare, but institutionally they still have structural gaps, and there is a stereotype way of thinking. So this requires a certain amount of change.
Now, ma'am, that brings me to my final question. Looking ahead, if you had to outline key reforms, what should India do to make the adoption truly child centric?
First, like I said, unified secular adoption code. Instead of three laws, we should have just one law. Even the rules regarding intercountry recognition or adoption should be codified, and it should be easily available. Then there should also be equality driven reforms or eligibility. Like right now, many people are out of the eligibility criteria. And maybe it's not very fair because many people want to become a parent, right? Just because they are not married, they should not be disallowed from adopting. I also feel that we require some institutional strengthening and support, like not only for the child but also for the parents. You need child rights professionals, you need social workers, you need psychologists, you need counselors. All these people will form a system, and that's important because when you are adopting, many things are there which only professionals can help you. So also I feel that since now the DMs and ADMs have to pass the order of adoption, they also require some specialized training. It's not that simple. And if we have a strong post-adoption support system, that will of course help the whole process. So I feel instead of having multi-layered and sometimes very confusing structure, we should approach for something that's very simple and straight, easy for everybody to understand. So I think with this we can wrap up this session on adoption, and now I'm passing uh, the weighted to Yash. Let him conclude.
Thank you so much, ma'am, for sharing your valuable insights.
Thank you, Yash.
I learned a lot from this conversation, and I hope our viewers also learned a lot from this.
I think they would. In fact, recently I saw a Hindi movie which is dealing with adoption by a single
Yes, ma'am.
parent. I have not seen the whole movie, so I think maybe our episode has come at the correct time.
Definitely, ma'am. Thank you so much again for joining in today, and thank you, viewers, for watching this video. If you like the video, please like it, share the video, and subscribe to our channel. Stay tuned.
I would also like to thank all the new subscribers. The fact that we have so many subscribers is now making us feel even more responsible, because we feel now we have to get the best of best of legal programs and discuss it in our podcast. And thank you for uh, recognizing our ability, and thank you for showing your appreciation. Till we meet again at the next episode. Thank you.